Housekeeping. The COVID-19 pandemic has required many adjustments to Texas legal proceedings, and the Supreme Court of Texas has issued emergency orders that require remote legal proceedings whenever possible. In accordance with those orders and in compliance with the local, state, and federal guidelines as to social distancing and group size restrictions, the Board of Disciplinary Appeals will hear today's cases through remote connection. We have made every effort to prepare for smooth proceedings over Zoom. Nevertheless, there may be glitches and we may need to take brief pauses while we resolve technical issues. We appreciate the patience of all participants as we adapt to remote hearings. If you get disconnected or have technology issues that prevent you from accessing your hearing, please let the BODA staff know. For purposes of today's hearings, the BODA staff can be reached by telephone at 737-704-8039. We will also post that phone number in the chat. While the use of technology makes remote proceedings a little different from our past en banc proceedings, today's hearings will generally proceed in the same manner as they would in person in the Supreme Court's courtroom. Please treat this Zoom meeting as you would the regular courtroom. Today's proceedings will be live streamed on BODA's YouTube channel, and the recording will remain there. Recordings will also be posted to BODA's website. We are now ready to proceed with the BODA docket for today's proceedings. I will begin by introducing the board and ask that each board member raise a hand as introduced. I am the chair, Kathy Kinzer from Dallas. Vice chair and chair-elect is David Gonzalez from Austin. Vice Chair Kelly Henson from Dallas, and I don't know that she's here. Mike McKetta from Austin. Deborah Pullum from Tyler. Mike Mills from McAllen. Mike Gregory Denton. Mike Gross, San Antonio. Nancy Stone, Amarillo. Jessica Barger, Houston, who is not here, correct? I don't see her. Guy Choate from San Angelo.
I'm here.
Oh, sorry, Jessica. Jessica Barger from Houston. Sorry, I missed your picture. Guy Choate from San Angelo and Joe Cleveland from Fort Worth. Our members can easily be identified on Zoom today by either the courtroom background behind them or by BODA beside their name. Today we will hear three cases. We will first hear our compulsory discipline case, then we will hear two reciprocal discipline cases. We did have on the docket a revocation of probation, but that case has been, an agreed order has been entered, so we will not be proceeding on that today. We have provided counsel and parties with comprehensive sets of instructions and guidance for these remote hearings. We expect that you have carefully reviewed those instructions and are prepared to comply with them. A few brief reminders before we get started. To ensure that we provide the parties with the best possible remote hearing experience, when we call a case, we will move non-participants into our virtual waiting room. When your case is called, you will be moved from the waiting room to the meeting for your hearing. The rule as to witnesses will be invoked in our virtual courtroom. Witnesses will only be permitted in the Zoom meeting during their testimony. While witnesses are in the waiting room, they are not to watch the live stream. Counsel and parties must not assist the witnesses in violating the rule in any way. The board instructed parties and counsel to submit electronic files of any potential exhibits in advance. All exhibits still must be offered into evidence and admitted by the chair in order to be considered and made part of the record. If you wish to offer an exhibit that was not submitted in advance, you must request leave to do so. You may request authorization to use the screen sharing feature to display exhibits that have been admitted, but the document shared must be identical to the document in the record. You may request a breakout room to confer privately. Breakout room discussions cannot be seen or heard by the board, and they will not be recorded or live streamed. You may make use of Zoom's private chat feature, except that counsel and parties may not use chat to communicate with witnesses in violation of the rule. Please do not upload or share any files through chat unless invited to do so by the chair. Please do not message the board through chat. BODA will not record or retain any chat messages. Remember that Zoom will pick up any background noise, so please silence any notifications on your device. Before speaking, please make sure that you are not muted. We have a court reporter present, and she will make the official record of today's proceedings. We will record today's proceedings for posting to our website. Any other recording is prohibited. We are now ready to proceed, and I will now call the docket. The first matter is a compulsory discipline matter, in re Guillermo Vega Jr., BODA case 64481. Is the commission ready?
Judith, you're muted.
No, I tried to unmute it and the chat showed up, so I apologize. Judith DeBerry for the commission, we're ready.
How much time do you believe you
probably
need?
5 minutes.
Okay. Is the respondent or someone representing the respondent present? Have we heard anything from the respondent?
We have not.
Okay. All right. The next matter is the reciprocal discipline matter, in re David Andrew James, BODA case number 64476. Is the commission ready?
Judith DeBerry for the commission. Yes, we're ready to proceed. 5 minutes.
5 minutes, okay. Is the respondent or someone representing the respondent present? Have we heard anything from the respondent?
We have not.
The third matter is reciprocal discipline matter, in re Lon Darley, BODA case number 64477. Is the commission ready?
Judith DeBerry for the commission. The commission's ready to proceed.
And how much time do you need?
5 minutes, I'm sorry.
Okay. The last matter is the Portley matter, which I previously referred to as an agreement has been reached, and we will not be proceeding on that case today. That completes the docket call. We will take the cases in order in which they were called, beginning with Mr. Vega's case, case number 64481.
Thank you. May it please the board. This is a compulsory discipline case, respondent's conviction on May the 23rd, 2018 for failing to file a report of cash payment over $10,000 received in trade or business in violation of Title 31 United States Code sections 5331 and 5332 in the United States District Court for the Southern District of Texas, Brownsville Division. We filed our petition for compulsory discipline on June the 10th, 2020. Respondent was personally served with the petition and notice of hearing on June the 15th, 2020 by Miguel Garza, a private process server. Proof of service has been on file with the board since July the 13th, 2020. On October 25th, 2017, in cause number B151012, style the United States of America versus Guillermo Vega Jr. in the United States District Court for the Southern District of Texas, Brownsville Division, respondent was indicted with count 1, willfully attempting to evade and defeat income tax due in violation of Title 26 United States Code section 7201. Count 2, willfully making under the penalty of perjury a material misrepresentation of his earnings on his United States individual income tax return in violation of Title 26 United States Code section 706 parentheses 1 close parentheses. Counts 3 through 7, knowingly and willfully filing a false report of cash payments over $10,000 received in a trade or business in violation of Title 31 United States Code sections 5331 and 5331 and 5322. Count 3 was for the representation of Jose Luis Zuniga. Count 4 was for the representation of Jose Luis Duentes. Count 5 was for the representation of Armando Arismendi. Count 6 was for the representation of Juan Racon, and count 7 was for the representation of Humberto Bazan. On May the 16th, 2017, in the same cause, respondent was charged by superseding indictment with counts 1 through 7, where the same is charged in the indictment. Count 8, knowingly and willfully filing a false report of cash payment over $10,000 received in a trade or business for the representation of Omar Canales, AKA Botas, in violation of Title 31, United States Code, Sections 5331 and 5322. On January 24th, 2017, respondent was charged with a second superseding indictment, and in this case, counts 1 and 8 are the same as the superseding indictment. Count 9, corruptly by threat and by threatening communication, influence, obstruct, and endeavor to corruptly influence, obstruct, and impede the due administration of justice in the United States of America versus Guillermo Vega Jr. in violation of Title 18, United States Code Sections 1503 and 1503A. And count witness tampering in the United States of America versus Guillermo Vega Jr. in violation of Title 18, United States Code Section 1512B1. On May the 23rd, 2018, a plea agreement was entered in cause number B-15-1012-S2, styled the United States of America versus Guillermo Vega Jr. in the United States District Court for the Southern District of Texas, Brownsville Division, wherein respondent pled guilty to count 7 of the indictment, of the second superseding indictment. The government would dismiss all remaining counts at time of sentencing. The defendant agreed to make full restitution of the tax loss and pay the United States clerk a special assessment in the amount of $100 per conviction. On October the 24th, 2019, a judgment in a criminal case was entered in cause number 1-15-CR 1012-S2-001, style the United States of America versus Guillermo Vega Jr. in the United States District Court, Southern District of Texas, Brownsville Division, wherein respondent pled guilty to count 7SS on May the 23rd, 2018, failing to file a report of cash payment over $10,000 received in a trade or business in violation of Title 31 United States Code, Section 5332 and 5332. Respondent to the custody of the Federal Bureau of Prisons to be imprisoned for a total term of 13 months. Upon release, respondent will be on supervised for 3 years. He was further ordered to pay an assessment of $100, a fine in the amount of $100,000, and restitution in the amount of $126,253. He is currently serving his sentence at home. At this time, I would like to offer the following exhibits. Exhibit 1 is a certified copy of the indictment dated November 12th, 2015. Exhibit 2 is a certified copy of the superseding indictment dated May the 17th, 2016. Exhibit 3 is a certified copy of the second superseding indictment dated January the 24th, 2017. Exhibit 4 is a certified copy of the plea agreement dated May 23rd, 2018. Exhibit 5 is a certified copy of the judgment in a dated October the 24th, 2019. Exhibit 6 is my original affidavit attesting to the fact that the respondent is the same person as the defendant in the criminal case. Exhibit 7 is the original certificate from Blake A. Hawthorne, clerk of the Supreme Court of Texas, dated July the 8th, 2020, indicating that respondent is licensed but not currently authorized to practice law in the state of Texas. And Exhibit 8 is a certified copy of an agreed judgment of private reprimand dated October the 10th, 2000 in grievance case number S204002936. And I ask that these exhibits be admitted at this time.
They are admitted.
Thank you. We respectfully seek an entry of judgment of disbarment.
Does anybody have any questions?
Yeah, Mr. Berry, Joe Cleveland for the board. What is the legal basis for the CDC's contention that a violation of the failure to report statute is a serious crime under the Texas Disciplinary Rules of Procedure 106 GG?
It would be because it's deceitful. It would meet the standard of a crime involving moral turpitude based on the deceitful nature of the action.
Is deceit an element of the crime?
I would have to, and I apologize, I don't have that right at this time. Can I brief that for you all and get it to you?
Do you think that a failure to submit a report is a crime involving moral turpitude?
I do. I think it's dishonest.
Does a criminal defense attorney have a duty not to disclose privileged information about who is paying his or her fee?
This, I'm sorry. We do not know who actually paid the fees. All we know is who the fee was paid for the representation of.
Yeah, but does an attorney have an obligation not to disclose who is paying his or her fee for the representation of the client?
I would say probably yes, but he still has to report that to the.
Isn't that a disclosure of attorney-client confidences to the government?
He has to report his income without it. He doesn't necessarily have to report where it came from, but if I don't know exactly what the, and I can get that if you need it. The indictment just said it was for the representation of, did not say who actually paid the fee. Now, does he have to say where he gets it? I don't know what the federal statute requires. I know he's required to report the income, which he did not do, which is dishonest.
Is the board just to look at the elements of the crime to determine if it involves a crime of moral turpitude, or is the board allowed to look beyond the statute to the facts that are presented in the evidence you've provided?
They're to look at the elements of the crime.
Anyone else?
Yes. I don't want to interrupt Joe if you're still going.
I'm finished. Thank you.
So, Mr. Berry, I have a question about the exhibits.
Yes.
Because the first few exhibits are just the indictments. And I know in many of our criminal trials, the first thing that it says in jury instructions is the indictment is not evidence. Now, in one of the portions of the exhibits, there is an agreed factual basis for the plea, and it's very different than the indictments. And so to what extent is there supposed to be evidentiary value in the indictments themselves for the dismissed counts?
I don't think there is, frankly, and I would agree with that. We do that to present a total record to the board so that they have everything that we have on this generally. So, but as far as for compulsory discipline, I think it goes to the count to which he pled guilty.
Thank you.
You're welcome.
Anyone else? Okay, the board will take this case under advisement. We are now going to hear the In re David Andrew James, BODA case number 64476.
Thank you. May it please the board, this is a reciprocal disciplinary action, part 9 of the Texas Rules of Disciplinary Procedure based on respondent's professional misconduct and disbarment in Florida. The petition for reciprocal discipline was filed with the board on June the 9th, 2020, and an order to show cause was issued by the board on the same date, requiring respondent to show cause within 30 days of the order why identical discipline should not be imposed. We was served by personal service on June the 30th, 2020, with the petition in order to show cause by Arturo Gonzalez, a private process server. Original proof of service was filed with the board on July the 16th, 2020. On May the 23rd, 2019, an order issued by the Supreme Court of Florida in the matter styled the Florida Bar Petitioner versus David Andrew James Respondent, cause number SC 19-226, lower tribunal number 2019-90042 OSC, found that respondent was in contempt of that court's order in the Florida Bar versus James, cause number SC 18-917, dated August the 24th, 2018. Respondent was suspended for 3 years. On February the 20th, 2020, for contempt in order to show cause was filed with the Supreme Court of Florida in the matter styled the Florida Bar Petitioner versus David Andrew James Respondent, Florida Bar file number 2020-90029 OSC, I'm sorry. On March the 30th, 2020, an order was issued by the Supreme Court of Florida in the matter styled the Florida Bar Petitioner versus David Andrew James Respondent in cause number SC 20-254, lower tribunal numbers 2020-0029 OSC, finding that James was held in contempt of the court's order dated May 23rd, 2019 in cause number SC 19-226, and respondent was disbarred from the practice of law in Florida and was ordered to pay cost in the amount of $1,250. This time I would offer exhibit number 1, which is a certified copy of the order issued May 23rd, 2019 by the Supreme Court of Florida in the matter styled the Florida Bar Petitioner versus David Andrew James Respondent, cause number SC 19-226, lower tribunal number 2019-90042 OSC. Exhibit 2 is a certified copy of the Florida Bar's petition for contempt in order to show cause entered on the 20th, 2020 under cause number 2020-90029 OSC. Exhibit 3, certified copy of the order issued by the Supreme Court of Florida on March the 30th, 2020, under cause number SC 20-254, lower tribunal number 2020-90029. Exhibit 4 is the original certificate of Blake Clay Hawthorne, Clerk of the Supreme Court of Texas, dated July the 13th, 2020, showing that Mr. James is licensed, currently authorized to practice law in the state of Texas. Exhibit 5 is a certified copy of a default judgment of suspension entered in BODA case number 61331 in the matter of David Andrew James, dated January 28th, 2019. And Exhibit 6 is a certified copy of a default judgment of suspension entered by the Board of Disciplinary Appeals in case number 61332, dated January 28th, 2019. The respondent currently resides in Florida, and I would ask that these exhibits be admitted at this time.
They are admitted.
We seek disbarment as reciprocal discipline to Part 9 of the Texas Rules of Disciplinary Procedure.
Does anybody have any questions? Okay, the board will take that under advisement. We are now ready to proceed on N. Ray Lon Darley, BODA case number 64477.
Thank you. May it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on respondent's professional misconduct in the and disbarment in the state of Oklahoma. The petition for reciprocal discipline was filed with the board on June the 9th, 2020, and the order to show cause was issued by the board on the same date, requiring respondent to show cause within 30 days why identical discipline should not be imposed. Respondent was served by personal service on June the 25th, 2020, with the petition in order to show cause by Phil Spencer, a private process server. The original proof of service has been on file with the board since July 13th of this year. On May the 28th, 2019, an application for order approving pending disciplinary proceedings was filed with the Supreme Court of the State of Oklahoma, and the matter styled State of Oklahoma, ex-rel, Oklahoma Bar Association complainant versus Lon Jackson Darley, III, respondent OBAD number 2239 SCBD number 6802. On or about June 10th, 2019, an order approving the resignation from the Oklahoma Bar Association was entered in the Supreme Court of Oklahoma. In this matter, under number SCBD number 6802. Finding that Lon Jackson Darley III offered to surrender his license to practice law, that the Oklahoma Bar Association investigated grievances filed by Lant, Gallup, and Lee Loggins, which served as a basis for the discipline. If proven, those grievances would constitute violations of the Oklahoma Rules of Professional Conduct, including 1.1, competence, 1.15, safekeeping of property, 1.3, diligence, 1.4, communication, 8.4a, misconduct involving dishonesty, fraud, deceit, or misrepresentation, as well as rules 1.3 and 5.2 of the Oklahoma Rules governing disciplinary procedure and respondent's oath as a licensed attorney in Oklahoma. The court ordered that the resignation of Jackson Darley was approved and was deemed effective on May the 28th, 2019, and that he would pay cost in the amount of $1,307.26. This time, I would offer the following exhibits. Exhibit 1 is a certified copy of an application for order approving resignation pending disciplinary proceeding filed with the Supreme Court of the State of Oklahoma. In the matter style State of Oklahoma, ex-rel, Oklahoma Bar Association complainant versus Lon Jackson Darley III, respondent, OBAD number 2239, SCBD 6802. Exhibit 2 is a certified copy of the order approving the resignation from the Oklahoma Bar Association pending disciplinary proceeding that was entered on June the 10th, 2019. Exhibit 3 is the original certificate of Blake A. Hawthorne, clerk of the Supreme Court of Texas, which shows that respondent is licensed and currently authorized to practice law in the state of Texas. A certified copy, Exhibit 4 is a certified copy of the agreed judgment of public reprimand along with agreed findings of facts and conclusions of law dated October the 29th, 1990, entered in grievance case number 68225-90 style complaint against Lon Darley, Dallas, Texas. Respondent currently resides in Oklahoma City, Oklahoma, and I request that the exhibits be admitted.
They're admitted. Anyone have any questions?
Thank you. We seek reciprocal, disbarment as reciprocal discipline.
All right, the board will take that under advisement. That concludes today's proceedings before the Board of Disciplinary Appeals. We are adjourned, and board members, you should have a link to where we are going to have our discussion next. Thank you so much.
Thank you.